Right. Hi, everybody. It will be wonderful to see you all, whoever's joining in. We're doing our sessions after a very big gap, but this session is coming on very high demand. A lot of women write to us or ask us indirectly or directly about things like will planning. Do I need to get a will made? Should it be registered? What happens in case, my spouse is not around? How do I secure myself? How do I secure my children, etc.? And I also believe that now in a situation where many of us as women have started creating our own wealth, right? It's even more important for us to also recognize how to make sure that this wealth is being passed on to the people we want it to go to. All the work that we do during our lives is actually the legacy continues the way we want to. And I think women do really care about their next generation. They really are very thoughtful about this, which is why I think this is a very relevant session. And Aditi is absolutely been very nice and kind to come in and do this session with us. So quick introduction of Aditi and Yellow. Yellow is actually a platform which is now enabling will making and trust making to the masses, anything which is getting democratized and available to all of us. I love it. I think it's so important that all of us should be talking about it. All of us should know about it. And Aditi herself, comes from many years of experience in working in this space with wills and especially creating trusts with multiple financial companies. She's helped a lot of high net worth individuals to do this. So we are in good hands. And like I always believe that, when we don't know something, we should lean in on an expert who can help us with that. So she's going to be that expert. And Aditi, I personally also have lots of questions for you today.
Yes.
So thank you so much for coming in and doing it for all of us women. And the floor is all yours, Aditi, to go and take us through how we can get started with planning our legacy smartly.
Yes. Thank you so much for such a kind and a warm welcome. And yes, I'm really, really looking forward to this. Actually, it's amazing to see the shift. There's a paradigm shift, especially with our generation where women are coming forth. We're working, you very correctly put, we have a wealth and we have a family that we have to take care of. So essentially, the whole essence of today is why making a will is especially more important for a woman. I've tried to make the PPT as feminine as possible. I've used colors and stuff. So this is not really like a mundane. I'll assure you about that. Okay, with that, I'll just quickly share my screen. Okay. You guys are able to see my screen? Okay, great. All right. So in addition to, what you just heard about Yellow, I'll just take a minute. Essentially, the main reason why Yellow was formed was that there was a huge gap in the market. Of course, the high net worth individuals and the, the NRIs and, that bucket, they, of course, had access to lawyers and they were okay kind of, paying a certain amount of fee. But then when Nikhil and I connected, we realized that this is a must for everyone. It does not matter if you have a lakh, if you have 2 lakhs, if you have 10,000 rupees, you need a will to pass on that asset to someone. And hence, that is why that led to the birth of Yellow. Yellow is India's first of its kind app through which, you punch in a few details and you have all the legalese which is covered in the app. Now, there's one more premise on which Yellow is formed. When we lose a loved one, there's obviously a lot of shift, right? You're emotionally going through a certain period of time, and you may be in need of certain money. Yellow also helps with the post-demise asset transfer. And, because honestly, like this is our bread and butter. There's so much running around to do. And because we know all of this, we want to take care of it on your behalf. So I'll take you through our services a little later. But first, my aim today is to educate you and convince you to make a will. Whether or not with yellow, you of course, can take a call, but essentially you must create your will. And, obviously by the end of the session, we'll see how many of you are convinced and how many of you have got like more queries. Okay, now let's dive right into this concept. When we talk about estate or succession planning, generally, when you talk about succession, people think, oh, succession in terms of who's going to be my next in line in the company. Or I've got this so many times, estate planning. Oh, is it real estate? Are you into real estate? So that is also one misconception. So today, essentially, we'll cover what are the basics, what is the concept all about. There are a lot of misconceptions in this space, so we'll bust all those myths. Now, there are several estate planning tools, which you can use to plan your succession. So I'll talk in briefly about each of those, and we'll see, how as per situation you can choose the estate plan what works for you. Today we'll focus more on wills, because that's like the most predominant and the fundamental amongst all the estate planning tools. And of course, I'll talk a little bit about yellow. I'll show you a demo of the app, again, very colorful. So, which is, going to make it a very smooth and easy journey for you. Okay, let's dive right into this. So essentially, even before we start talking about what is estate planning, let's understand what does a wealth journey of an individual look like. So, we as Indians, it's ingrained in us that we need to save. I'm not talking about the Gen Z and after that, but otherwise, as an Indian, it's ingrained in us that we need to take care of our family, our children, and sometimes even grandchildren. We think about our children's education, marriage, and whatnot. And because of that, we always keep some portion aside for our family. But the issue happens here is that even though we have, the heart is in place, we have the intention, but because we don't create an estate plan, those our wishes and our wills don't really get fulfilled. And because of that, there are certain consequences which come into picture. Now, some hard-hitting facts I want to share with you. In India today, 150,000 crores of assets are lying unclaimed. And, this is only financial assets. I'm not even talking about the real estate part. Most of it is in Indian banks and insurance companies. There are two primary reasons for this. First one is, see, most of the times, Indians are also not very good at having those conversations with our children. We don't even know the existence of assets. Like, how many of us know what is the bank account number of our parents? Or how many of us know that, probably dad or mom may have bought some bonds, to save upon some tax. We are generally not aware. So because of that, obviously, families don't come forth and claim those assets. Secondly, when you don't write your own will, there are several processes that you need to follow. I'll talk about that a little shortly, but there are several processes you need to follow in order to claim those assets. So sometimes the cost of, getting all the documentation in place actually exceeds the amount which is there in the financial institution. So because of that, unfortunately, this is like young corporate India's money, rather, hard-working individuals, taxpayers, their money is stuck. Also, unfortunately, 76% of the disputes that are there in Indian courts are because of property and family-related disputes. And lastly, if you're lucky, it takes around 3 years to complete all the formalities, post-death. But of course, if there's any litigation or anything gets stuck, then we've seen enough Bollywood movies to know that there is no time you can, fix to getting your disputes resolved. Now, although we'll be talking about why a will is important, I think it's imperative that we first understand what happens when you don't have a will. See, essentially, when you own any asset, all right, whether it's a bank account, fixed deposit, real estate, etc., there are essentially two ways through which the asset is passed on. One is with a will and one is without a will. That is, with a will, we call it testamentary succession, and without a will, we call it intestate succession. Now, when you don't decide who should get your assets, the law decides on your behalf. This means now each one of us here today, we're born in a family which follows a certain religion. That religious law starts governing. To give you an example, in case of a Hindu married female, her husband and children are the rightful heirs. Now, laws are different for male. They're also gender specific. In case of a Hindu male passing away, his mother, his wife, and children are equally entitled to the asset. So, we have this misconception that, oh, if my spouse is not there, I will get everything. That's not true. There are a lot of other dynamics which are involved. Now, so there's one specific law, like rather there's each religion has its own specific law. So you've got separate law for Hindu, Christians, Muslims, Parsis, etc. Now, when you don't write a will, and let's say you have a bank account, you have a mutual fund, etc. When you go to the bank, how will they know that you are the rightful heir or not? So they will ask you to produce all the proofs. See, nominee does come into picture, but I'll park that aside for the time being. I'll give you that example too. But when let's say most of the times, people don't even update their nomination. So let's take an example where you even don't have a nominee. How does a bank know that it's just one family member left behind, or there are 3, or there are 5? That is why they ask you to, procure documents like legal heir certificate. It's called succession certificate for some purposes. Letters of administration in Bombay, Madras, Calcutta. It's called Pedi Nama in Ahmedabad. I'm not trying to scare you away, but I'm giving you an example that how in different places you've got like different nitty-gritties and different processes, because of which all this entire process becomes very complicated. And naturally, when you need to go to court to procure these documents, the entire process is emotionally and financially very draining. And of course, it, takes months at end to get those documents. Okay, so we'll be busting some myths. There are a lot of misconceptions, in this space. The most important one is people think that if they have a nominee in their assets is as good as making a will. Now that, is one of the most predominant reasons why people think that they don't need a will. Now, let me give you an example. For most asset classes, there are a few exceptions, but today we'll focus on the general law. For most assets, your nominee is only a custodian or a trustee. This means your nominee can, in case if you don't, leave behind a will, your nominee can go to the bank, collect the asset, but your nominee can't enjoy the asset. Basically, your nominee can't spend that particular amount because it's the rightful legal heirs who are entitled to that asset. I'll just give you an example. Let's say I have an HDFC bank account, and most of us start working when you're, let's say, 23, 24, you're not married at that time. So you appoint either your mom or your sibling or parent, somebody as the nominee. Now, let's say if I appoint my sister as a nominee to my HDFC bank account. If I pass away without a will, my sister can go to HDFC bank, collect the money, but she can't spend it. She has to give it to my husband and my children because they are the rightful owners of that particular amount. So always remember, your nominee is only a trustee or a custodian, and your nominee has no right on your asset. People also think that you need a lawyer to make a will. And, once a will is made, it has to be notarized, stamped, or registered. Now, being a lawyer myself, I can vouch for a fact that, especially with the Yellow app, You can punch in some details. Imagine the kind of privacy today that technology is giving you. You don't need to reach out to anybody. You can create a will through the app. But there's no legal requirement that a lawyer only has to make a will. People also believe that will has to be notarized, registered, stamped, but these are not requirements as per law. See, registering a will has its own advantages, and I'll talk about that shortly. But just because you've not registered your will, it doesn't make it invalid. I touched upon this. People also think that everything will go to my partner as it is. So why do I really need a will? But again, that's not true. It's always a bunch of people who inherit your assets. It's never only your spouse. In some religions, grandparents have a share. In some religions, parents. In some religions, it's the spouse and children. So the dynamics depend largely on your religion. There's one more misconception that you need to make a will only when you're old or unwell, or when only that if you have a certain net worth. But again, that's not true. There's also one more misunderstanding that, it's super tough and costly to make a will. If you hang around, by the end of the presentation, you'll see how pocket friendly can be creating your will. And lastly, there's one more myth that people think that they will lose control over their assets if they make a will. Now, actually, that's not true, because your will comes into effect only after your demise. So before that, those assets remain yours, and you can obviously keep changing your will from time to time. All right, so let's look at what are the various estate planning tools which are available. So amongst all these, circles that you see here, we first start with the will. Now, a will is the most important and fundamental tool amongst all of these, because will essentially covers all your assets till the time you're around. The other tools, I'll talk about that. The other tools are very, goal specific. So let's say, I think I'll first just talk a little bit about a will, and then we'll touch upon the rest. Now, will essentially is a document in which you write down about your family, you write down about your assets, and you essentially mention that who should receive which asset upon your demise. To make a will legally valid, you need to be 18 years of age. You need to be of sound mind, which means you're capable of understanding your actions. You need to put a signature on your will. Wet signature, digital signatures are not permitted in India on a will. So you need to put your wet signature, and you need 2 more witnesses to also, basically see you sign the will, and they also have to put their signatures. That is it, and it becomes a legally valid will. It can be on a plain paper. We've seen, wills at law school, we've studied that wills were written on tissue papers, on the back of a, car. All those wills were also held valid. Those were made in certain situations, when people were in like tough situations. But essentially, it's so simple to create a will. Let's move to the next instrument, trust. See, sometimes what happens is you may not want your children to receive a lot of, cash or amount when they're very young, because they're impressionable, right? So in that case, what, a person called as a settler, that is a person who owns that asset, he identifies a few trusted people. They're known as the trustees. So let's say if I appoint, Nidhi over here as my trustee. So I'll be like, Nidhi, can you please take this 5 lakh rupees that I have, and you give it to my children when they turn 30. So you can plan your, in an intermittent fashion, or you can have these conditional distributions or intermittent payouts from a trust. That is not possible in a will, because through a will, there are bullet payouts which are made to your family. So trust is a little sophisticated structure. Does everybody need a trust? The answer is no, because in a lot of situations, a simple will can suffice. But let's say you're looking at consolidation of assets, or like I said, you want to make intermittent payouts. or let's say there's a child with special needs, or let's say looking at business succession of whatever assets that you have, promoter shareholding, then trust is a good option. But a trust does not replace a will. It'll always be will plus a trust, or it'll be will plus a gift deed. Now, I think Z also had a question on what is a gift deed. So essentially, see, like I said, in a will, you don't lose control over your assets, right? Like till the time you're around, those assets belong to you. That's exactly opposite in case of a gift deed. Now, in a gift, if I gift my assets to someone, I lose control over that asset. It's important to mention here about the Raymond family. So we know about the Singhania. Raymond is a household name. Senior Singhania gifted a chunk of his assets to his son. Things went sour between the father and the son. Because of that, Senior Singhania lost a substantial amount of his wealth because he lost control. And, almost to the extent that he had difficulties maintaining his lifestyle. So gifting is okay, but only a certain portion of your wealth. Not in you should not be giving out substantial portions. So let's say if you've got, you have a son and a daughter, and you want to, and let's say you have let's say you've got 5 flats, but you want to make sure during your life, at least 1 flat each, you want to give it to them. So in that case, gift may be an option. Coming to the next point, joint holding. People also think that, husband, wife, we're owning the house together. If he passes away, it's all mine. That's not true. Because when you own a joint asset, it's presumed that, 50% is held by both of them, unless, of course, shares are specified. It can be 90-10 also. But the point is, if one person passes away amongst the 2 or other owners, then his or her portion of the asset passes on as per his will or intestate succession, essentially. So I'll just give you an example to simplify this. Let's say husband, wife own the house together. Husband passes away. If he has 50% share, his now 50% will get divided between his wife and children. And of course, if he has a mother. So then how many people become owners of the assets? The wife, the mother, and the children. So always remember, especially in case of immovable property, just because you have a joint holding, it does not mean that you don't need a will. But with a bank account, if you have a either or survivor clause, which means that if one person is not there, the other gets the entire amount. But then again, does that rather do away with the need of a will? No, because after that, what? One person is not there, okay, next gets the amount, but what about the next in line? So it's always good to plan this out. Coming to the last point, nomination. See, although technically it's not an estate planning tool, but nominations are very important because asset transfer becomes very easy. So you must always synchronize your nomination with your will. I'll go back to my example, HDFC Bank. If I wanted my husband to get the amount, I should make him as a nominee. If I want my sister to get the amount, I can make her the nominee, but I should also mention her name in the will. So if let's say, you want let's say you want one mutual fund to go to your brother. So make him the nominee and add his name in the will. Because if you make your husband as a nominee, the husband has to give it to the brother. What if they don't get along well, or there are issues, or what if there's a misunderstanding, all of that. So it's always good to synchronize it. I think I've thrown a lot at you. I know it's a lot of process. So I think we'll pause, take a short break here, and we'll address, questions that you have.
Yeah, I think we're raring to go. The right side of my screen is full of questions, including many from my side, I have to confess.
Yes, please.
Okay.
I'm all yours.
Okay, so I'm just going to ask one question, which is my question, and then I'm going to pull out everything. Because coming back to the part we ended, which is around nominations, one of the things which really concerns me is, and in our planning when we're talking to clients, when they're doing advisory and wealth investments, etc., is that we want them to make nominations, right? That's very important. But I want to ask, what happens in case I miss out, like I don't make a nomination? So will is step number 2, but I'm saying nomination hi nahi hai. I've forgotten to do that. What does that mean for, my children or for my husband? Like, what is that? What is the implication of that?
Okay. So the implication is, now when there's no nomination, let's take a bank account. Let's take a simple asset. Let's say HDFC Bank, nomination nahi hai. Now let's say if I pass away, now if my husband has to go to the bank, let's say husband knows that, I used to bank at so and so, he will go there. The bank guys are going to ask him to produce all those documents. For example, I'm here based out of Pune. They will ask him to produce a legal heir certificate. So he needs to go to civil court. He needs to file the application. Who are the rightful heirs? So let's say my husband, I don't have children, but it's easier to give that example. Children, etc. They will have to, write everything, say. So then the court establishes, now there are 3 people or 4 people, and these 4 are entitled to the asset. And then the bank hands over that amount to either one of them. Basically, the other can say that you can all transfer to his account, and essentially all of them become entitled. So now I'll give you a simple example. Asset transfer, how will it happen? With a will in this case, or rather with a nominee, without a nominee. So same example, if nomination is not there, my husband has to go to court, get all of that. 6 to 12 months it will take him to get hold of the amount which is there in the bank, if everything goes well. But if he was a nominee in that bank account, he has to submit a death certificate. Probably a week's time, he'll get the money.
Got it.
That is the importance of a nominee.
Basically, it's the time and the effort and energy which is going into this recovering of assets. I also think sometimes, Aditi, I think it's my assumption, you can correct me, is that I also feel the lack of nominee many times in our family, especially, also ends up leaving that money which you were saying, like you don't even know that there was somewhere, because you are not a nominee, nobody is even kind of reached out to you, or you have no track of this asset existing at all.
Exactly. And I'll tell you what, it gets a little more complicated than that. I mentioned, right, for nominee, there are 2-3 exceptions. So for provident fund, life insurance, and for, pension, the nominee is the owner of the asset. But now for employee provident fund, let's say, let's say we all start working 23, 24, we're not married. Let's say that time I make my mother as a nominee. But when I get married, that nomination becomes invalid. How many people are even aware of that? So technically,
what happens to my mom?
No, by the fact itself, she stops being a nominee. So when you get married, that nomination becomes invalid. So you're actually supposed to update your nominee from time to time. Nobody educates us on that.
So my husband, if he goes, his mom gets access. But when I go, my mom gets no access.
No, in that sense, no. So that law is there, yes. I'll come to that.
Okay. I think
case study. But just to give you an example, like mom or sister, what if I make her a nominee to my provident fund, and if I get married, after that basically her nomination becomes invalid. It's my husband then who gets the assets, irrespective of whether who I make as a nominee earlier, because the law says that. But that's only for employee provident fund. It's not that, like I'm telling you, our laws are complex, and that is the reason why that we must assess this, take a look at it, and see, because honestly, we've got so much going on in our lives that this is such a low priority for most of us. It's low priority. But life is uncertain, and all this. And this can actually lead even from a financial hygiene perspective, this can actually lead to erosion of wealth, because the amount you end up spending to get what is rightfully yours. But all this can be simply done away with if you just take probably an hour or 2 on a weekend, get together, just create a will,
Wonderful. Aditi, there are lots of questions, so I'm going to pick few, and we have some time, so let's go over it.
I've kept my afternoon free, so Don't worry, I'll patiently answer everything.
Thank you so much. Okay, so Rachna is saying we'd love to have like a checklist on ensuring what basic things can be done when there are siblings and parents want to divide equal assets. Like, Rachna, you can, if you want to unmute and you want to ask, you can just like do that.
So when they're siblings, it becomes very odd for parents to tell that please make a will and, divide whomever needs to get as per whatever you want them to get. But how can that be made easier instead of just assuming that, it'll go 50-50 to both the siblings?
Yeah, that's a very good question. And honestly, it is hard for parents, especially when they have to take a call. But to be very honest, if you just take a step back, all it takes is for them to, just plan around. Like, let's say if they want the house to go to the two of them, they can always mention that my house will go to my son and daughter equally. So both of them become owners of the house. Now, see, in some families, let's say already siblings are not getting along well. So then sometimes they mention, we've seen, we've seen enough situations where in those cases, either one thing is that parents can create a trust so that they create, separate structures for children. Or let's say they mention that, look, you both can be owners and then they can like have an understanding that they can sell off the house and then keep the money. So honestly, there is no one straight answer to this situation, but it's better to have a will than not a will, especially if there's a dispute, because when you're going to court to get those documents, you need NOCs from everybody. And if people are not on talking terms, which we've also seen, I will not give NOC because they don't understand the implications. And then again, that asset is like just left hanging. So, Rachna, I agree with you, but it's a conversation. It's a hard conversation, but it's important that parents also know that what their children will go through, when there is no will.
I just have one more question.
Please.
In most of, say, your financial assets, like, maybe a mutual fund, for example, okay, if you have nominated your brother in majority of the investments, now you're married and something has happened to you, for example, the husband automatically is a legal hire, right? So can he claim the money, or because I have left behind my sibling as the nominee, my sibling has the right to say that, okay, this money my sister has left behind for me? How does that?
Actually, no, that won't, because the essence is that a nominee is added only for the sake of convenience. See, as regards the institution, it's easier for that asset transfer, but actually your brother has no right.
You'll have to put it in the will, is what I understand from what Aditi spoke.
Yeah, because so Rachna, it's a very important question that you asked. So
I mean, if like you gave an example of the HDFC bank saying that if I am nominee, my husband ko kuch ho gaya, I will get the money. But who is there to monitor whom I give that money to? And what if I refuse to give that money? That I'm not giving you the money. The money is mine now.
No, they will sue you.
They can go to court if they have the money to go to court. Otherwise, you all will be sitting and doing dispute.
So ideal way, nomination is just like a safekeeper, and then it has to go to the legal hire, or you nominate you put it in the will that this is the norm. So he or she has to get that money, basically.
Absolutely. Like I said, right? Like if, let's say, same example, like if my sister and my husband, if they don't get along well, my husband has a right to sue my sister because it's his money as per law.
Wow.
Yeah, but if
this is getting more and more scary, Aditi.
it
I'm freaking out. The more you're talking, the more nervous I'm getting. I don't know about the other girls, but it's happening to me.
But this is a reality, Unfortunately, this is the reality. And that is why, by taking a simple steps, how much we can make our lives. See, honestly, we should not even think of the fact that, okay, when I pass away, and God forbid if my husband passes away, even his assets need to be in order for me to have, access to the
secure, whatever.
First part, worst part of this, I feel, from whatever I've heard little from you, is like my parents don't have a say in anything, whereas my husband's parents have a right over every.
No, only mummy. Only mummy.
Mummy.
Father
Only
comes in
mummy.
second line.
हाँ,
Mummy has.
father को
But
नहीं
mummy
मिलेगा,
के पास
mummy
भी
को
right तो
मिलेगा.
चला गया ना.
So as per my understanding of Hindu succession law, it's mummy, and then in the second tier, it's daddy. and
daddy.
whatever.
Yeah.
So I think, Aditi, there's an interesting question by Meenal. I'm not sure if she's here right now, but she says the same one, right? If one does not make a will, then do the assets automatically get transferred from the husband to the wife? I think this one, if you can just clarify one more time, because I think there's a myth, you rightly said. It's
Absolutely. Absolutely. So Meenal, again, very good question. If let's say husband doesn't make a will, the wife does not automatically get everything. In case of a Hindu, male, if a Hindu male passes away, then if his mother is there, his mother, wife, and children all become entitled to the asset. So it will never be ki husband gaya to wife ka sab kuch ho gaya. It's not like that. See, in some families where earlier, if situations are good, of course they give it to the wife. But legally aisa nahi hai. Legally, it's a bunch of family members, like I said. See, for example, in case of Christians, the mother doesn't come into picture. It's the spouse and the children who get it. There's a proportion. Spouse gets 1/3 and children gets 2/3.
Yeah.
But in Hindu law, it's
even
equal proportion.
Muslims, they have a similar kind of thing, right? Some part goes as charity, like there's some ratio.
Muslim dynamics change because firstly, a Muslim can make a will only with respect to 1/3 of their assets.
Yeah.
But the other 2/3 as it is go. But even in that, let's say now if you don't make a will at all, then again, depending on whether you're a Shia, whether you're Sunni, all those change. For Muslims, even grandparents have a share. 1/6, 1/5, 1/7. It's even more sophisticated and complicated. So,
but Meenal has a follow-up question, Aditi. Even if I'm nominated, Meenal, if you want to unmute and quickly ask. I saw her. So even if she's nominated, it will have to again be in the will. I think
yes.
Okay, I had another 2 questions. Sorry, Aditi, there's so many coming in. I'm just going to go like a machine over this. Xenia has a question around how to pass on assets to a minor in a will. That's one. And I also think Shilpa had a very relevant question around, I saw Shilpa, your question around husband and wife. Can husband and wife have separate wills? Or they need to have one will? I thought both of these questions were very relevant. And
yeah. So firstly, I'll come to the guardian part. So you can mention, even for a minor, it's important to appoint a guardian in your will, because a will is the only document through which you can appoint a guardian. I'll actually talk about that a little detail. I have a point. I've covered this point in the presentation. But yes, to just give you an answer. Yes, it's the guardian who will be taking care of your, so that the assets reach the minor. And as regards, I think it was Shilpa's question, if I'm correct, should you make one will or 2 wills? Always separate wills. You should have the control over your will. So tomorrow, if you're, whatever, if you're here today, somewhere or the other, one person is not going to be around. The other person should have a right to change it. See, today when everything is hunky-dory, we're like, arey, ek hi will hona chahiye. But then after some time, you'll have children, they'll have children, dynamics change, life changes. But you must have control over your assets. So always separate will. No matter how much you love your husband, sorry, dear, separate wills.
I think that's love too, right? Having the space to do what I want is love too.
Absolutely.
Great question. Diksha has a question. Witnesses of will, very good question, can be the same as the beneficiaries or different? Okay. So again, I'm really sorry if I'm going to complicate things for you a little. Go for it. See, as a general advice, it's a recommendation. It's nothing to do with the law. It's good if the beneficiaries are independent. So, for example, you can have, a trusted friend, etc. But
don't get witnesses like we do for leave and license agreement. Na kisi ko bhi driver se sign kara liya, the cook, if she's coming and helping, she is signing. But get somebody who is trusted, if possible. But otherwise, beneficiaries can sign in case of Hindu law, not other laws. But it, like I said, it's always good to keep it independent. It's always better that way.
Okay, this one is from me. We can take it later. Is creating a will one-time activity, or can we periodically update? I can tell that, and Aditi can answer.
Go ahead.
Aditi, you tell if I am right or wrong. Based on my
Yes,
limited understanding, yes, you can update your will till the time you're sound mind, and till like just before you die also you can update it, is what I know.
Yes, absolutely. I'll just add on to what you just mentioned. It is recommended that you update your will from time to time. Take a look at it, like how we take a look at our investments, right, on a yearly basis. Take a look at your will too. Does it need some change? Have your wishes changed? Have your desires changed? I'm not saying that it's compulsory to change your will every year. If your wishes are the same, it's good, but revisit it so that at least, see, if I make a will 10 years back, things are different in my life today. My assets may have changed entirely. My family dynamics would have changed. People may have had children, whatever. People may have lost some loved ones. So just basically,
people may have fought with me and I don't want them in my will anymore.
Yes.
Yes. Like, no, मैंने तुम्हें बेदखल कर दिया है अपने assets से.
Change.
Yeah, things happen, man. That's good. Okay, so many questions. Sejal is saying, if nomination for property of husband is done, okay, then it will be transferred to nominee, or wife and kids and parents all are nominated. I think.
Okay. Yeah. Okay, so this is also important to understand. As a general rule, like all across India, you don't have nominations for real estate. Only I have seen this specifically in Mumbai and Maharashtra. In that sense, we have cooperative housing societies. So we have like flats, and then they have nominations. Over there also, your nominee is only like a custodian. They don't have a right. Now, I'll give you an example. Now, let's say if husband is owning the house, he makes wife as a nominee. But then when the husband is not there, the wife will of course have her name will be entered in whatever the books, but she will not be the owner. All of them will again have a right. So again, it's the same rule. It's only as a custodian. So yes, we have to, make it solid by making a will. But otherwise, in most parts in India, there is no nomination. Let's say if you have a plot of land, let's say in Rajasthan, there is no concept of nominee there.
तो सब will से ही चलेगा. Zinat का last है. Transfer, are the transfers different for gender community? Yes, Zinat. Even before Aditi answers, it's like a very nice, complex whole law book, which Aditi is the master of. Community also wise it's different. So I always recommend, in my opinion, personally, if you all trust me, because I've done little bit of estate planning as a CFP. It was the toughest exam for me. But I can just tell you, it's if you're in a situation where you do feel that you have a large amount of assets and you would like to get, I would say get an expert opinion, khaskar in case of intercaste marriages, some sort of, unique scenarios. Like I asked a question about separation and divorce. What happens in case of automatically. So stuff like that, I personally do recommend getting in an expert. That's my thought. And Aditi can tell us how yellow helps there.
Yes. So see, in case of separation and divorce, what was the question? I think there was one question. Okay,
that was my question.
Okay, how does one structure their will in case of a separation or divorce? See, now this also depends. So let's say, for example, a will is going to suffice. You can mention, which assets should go to whom. But one more thing may become a little important is in case of, divorce, the guardianship part becomes a little complicated. See, as per law, the father is the first guardian, then the mother. But of course, if there's a divorce, the court appoints a guardian accordingly. So there's no one clear, straight answer in case of, divorce, which structure is more appropriate. It all depends on the situation. Sometimes in case of, divorces, we've also created structures for a couple when they're separating, because that understanding was there and assets could be moved. But sometimes, for some males, we've seen alimony has to be paid out, or let's say settlement has to be made. So, we work with the family lawyer to structure your estate so that we don't want any conflicts and complications later.
So I'm just following that up. So for example, if I am divorced, everything is done and all of that is done. It's okay. And we have a minor child. Okay. And something happens to me. And I don't have a will.
Yeah.
Who's going to get like all the assets for my kid are going to go to the ex-husband?
No, they don't go to the ex-husband, because the law says when they say husband, wife, it means lawfully married husband, wife.
So now who will get my money? And will
So
be
then
so wo intestate succession.
Yes, intestate succession, male, female, according to that will get.
तो मेरे केस में अब क्योंकि मैं मैरिड नहीं हूँ तो किसका पास जाएगा?
Then it will be your family members, your parents,
Brothers, sisters,
siblings.
all
Yes,
of that.
yes.
Oh, okay. So relaxing. Thank you.
I also have one more question, Aditi.
Please do.
So all this sounds, I mean, as easy as you're trying to make it in terms of what laws are there, and there are so many terminologies like a beneficiary, a trustee, or this or that. It sounds very complicated. I just want to understand if individually I need to make a will for obviously bigger assets of mine, just say I own a house and certain set of financial assets and stuff like that. How easy in terms of paperwork is it going to be to create that will and make those one or two people which I feel I want to leave that money behind for? How easy?
So then let's, we'll probably in the next 15-20 minutes, I'll be answering this question of yours. I'll take you through the demo of the app also, and I'll just show you how easy it is. And of course, if you still have any difficulty, I'm here to make things simple for you. Rather, I'm here to try and make things simple for you.
Okay. There are so many revelations that have happened today from even the 15 minutes that you have spoken, honestly.
So should we move on to the next part and then maybe there'll be another set of questions? I know Diksha has one, but I think Diksha, let's hold on till her second half and then
Sure. And I think some of these may get clarified while I'm taking you through the presentation itself. Okay, I'm so happy to see so many questions coming in, which also means that you've understood what I'm trying to. Rather, I have been able to convey a little bit about what the important bit is. But more than anything, please feel free to add in whatever questions you have, because this is a topic which is very dear to my heart and very, very important too. Okay, now why is a will important from a woman's perspective? So, I've just given you a little bit of data here to give you a flavor of what the law really looks like. So I've mentioned this before. If a female, Hindu married female passes away without a will, especially, if she, even if her husband is not around, it's her in-laws who get the assets before her parents. Now, if a Muslim male passes away, the wife is barely left with 1/6 to 1/8 of his assets. And that is a general principle in all religions. And, this is a uniform practice which has been there. See, one of the most important reasons to understand is laws are archaic in today's terms because all of them were enacted pre-independence era. Hindu Succession Act 1956, Indian Succession Act 1925. Society was different then, earlier when women were married off, the parents didn't want to do much with, her set of family. It was assumed that, okay, sasural mein she is, so those people will have the first right or whatever. That's how the society was. I'm not getting into whether it's right or wrong, whatever. And law generally reflects what the society really wants. But times have changed today. Unfortunately, our laws have not, which makes it all the more important that through a will, you can plan all of that. Otherwise, the laws decide on your behalf. See, somebody will get the asset, right? So either you decide or the law decides for you. I mean, the equation is as simple as that. Okay, now this is a case study. This is currently pending before the Punjab and Haryana High Court. This is, unfortunately, this was pandemic times. Lot of, we saw basically COVID did not see the age when, it affected people. A young couple passed away. They did not have children. Now, the daughter did not leave behind a will. So her mother-in-law had the access to the assets and not basically her own mom. Now, I'm not against mother-in-law receiving any assets. And I'm not here to start a new conversation on mother-in-laws. But to be very honest, if she had made a will, she could have planned that, okay, something should go to the mother-in-law, something should go to the mom, etc. She left assets worth 2.7 crores. And the mother has filed a case before the High Court saying that this is the Hindu Succession Act is unconstitutional. But the case is still pending. But the fact of the matter is that these are the circumstances that people face when they don't leave behind a will, because you then have to face the laws which unfortunately are not in times, rather not in line with the times that we are in. So yes, this is the sad reality, and that is why all the more I'm insisting that you must just make it a top priority and create your will. Okay, so now we'll start with, we've seen basically what happens when you don't have a will. So now let's see, why should you write a will? How easy it is to write a will? I'll touch upon that. And how should you execute a will? What steps can you take so your will becomes a very robust one? So this is going to be a quick recap of what we saw. It's the first and the most important aspect of an estate plan. When you make a will, you bypass your laws of succession. Asset transfer becomes very smooth in a will. Now, when you mention in your will, which assets you own, there is, of course, loss, the chances of loss in that transmission, where this means that where we don't even know about the asset, that aspect gets taken care of. A will definitely helps you to prevent disputes. You can plan who should get what. All those things can be taken care of. Now, with respect to a minor child, we had a question there, so I'll talk probably a minute on this. Now, I'll give you an example. As per Hindu law and most other laws, father is the first guardian and then the mother. In COVID, we've also dealt with a case where both parents pass away in quick succession, and either side of grandparents are fighting for the custody of the child. Now, who would know it better than you that who's going to be more compatible with your child? So will is the only mechanism through which you can appoint a guardian for your minor children. So especially if you have, young ones around you, please make sure you appoint a guardian. And lastly, it gives you the power of choice. You can choose who should get what assets. So, when we talk about assets, we always think bank account, mutual fund, house, etc. But what about the necklace which your mom passed on to you? Or what about, a beautiful sari which you own, or some handbags? There are so many assets that we have which have sentimental value. All those things can also be mentioned in your will. See, for example, I know that, oh, there's a necklace which my mom gave me. My sister will value it much more than anybody else. Mention that in the will. It doesn't only have to be, in terms of assets that we talk about, which are the usual assets. Anything which you own. It can be a piece of art. It can be a musical instrument. It can be anything that you own and you can pass on. All right. Now, how do you create, unknowingly, how do you create a good, robust will? Through the Yellow app. So I'll just take you through the important aspects of, how you can cover a lot of, anomalies when you create a will through the app. Now, I'll give you an example. Okay, we know that, if I'm not there, my husband should receive the assets. But have you thought about this, that let's say, if let's say if you pass away, your husband passes away shortly, what about after that? Have you thought about the next in line? Now, let's say you have, I talked about a guardian. Let's say that you mentioned one person as a guardian, but what if the guardian refuses to act as a guardian? Have you thought about what will happen after that? Have you thought about a backup guardian? See, there's something called as an executor in a will. Executor means a person who's in charge of, distributing the assets, taking care of the administration, making sure that assets reach your beneficiaries. See, there's so much work even post-death, right? If a person passes away in the middle of a financial year, taxes have to be filed, PAN has to be closed, Aadhaar has to be closed. All those things an executor has to take care of. Now, if I mention, let's say my sister is the executor. Tomorrow, if she moves abroad, or let's say, she has, let's say she's got a child and she doesn't have the time to do the running around. Have you thought about if she refuses after that, what? Because if you don't appoint an executor, you need to go to court to get an executor appointed. So all those things we've taken care of in the yellow app itself. So unknowingly, you create a goodwill. So Neha, I'll just share, my screen and I'll just show a quick demo of the app.
Yeah, absolutely.
Then, I'll just stop sharing it here.
Good question. Good question.
Okay, so essentially the reason why I have created a demo mock will here, it says continue my will. So, but essentially how it works like is, I'll press on continue my will. So so we've divided this into 7 cards. So you have personal details, you have my people. So personal details, you add your details, your name, date of birth, where you live. You can add your people, that is who will your beneficiary will be, who your assets, who your executor will be. And all those can be imported from your contacts. Then this talks about what your assets are. I'll open each of these and I'll just show it to you. Then essentially so first we talk about your assets, then we talk about how those assets have to be passed on. Then we talk about how you can appoint an executor of a will, guardians if you have minor children, and who your witnesses are. So we've divided into 7 cards. So all the important aspects are taken care of. Now you click on personal details and you can just add your information here, okay? When you're born, your address, etc., all those aspects. Sorry, I'll just go to the second card. You come to my people. You edit it, and here I can add whoever the people is. So let's say there's a sibling, I've added the sibling, there's a spouse, I've added the spouse here. So those people can be added. Now in this section, my estate, we've given you enough, pointers and asset categories that unknowingly you'll not be able to forget any asset that you have. Let's say if you have a bond, etc., we've categorized it. Now let's say in immovable assets, see, residential property, commercial property, agricultural land. So all those things can be added here. So you can just add a commercial property, add the details, add the address. We've also given an option, sometimes let's say there are too many khata numbers mentioned there. You just take a picture and you can upload it and it will become a part of the annexure. So similarly, you can add it for your agriculture and residential property as well. Moving on to the next asset class, bank deposit, financial investments, all these things already prompters are given to you. Business assets, if you have any proprietorship firm, company, etc., all those aspects can be mentioned. See, for example, I'll take you to the partnership one. See, name, address, holding percentage. Let's say you own 10%, 20%. Those aspects we mentioned. PAN, so easy for identification. And one more thing is, there are enough, so let's say you see a question mark here. So you have any specific query, you can explore the FAQs. See, because I've already added the details, but at every step when you go, you'll also get a little explanation, executor, there's enough and more literature and help which takes you through your life story. So, you can add all the details here. So digital assets, your crypto wallets, again, your other assets, jewelry, car, even for jewelry, right? How do you exactly, this is one common mistake, I've seen, especially when I was working with a law firm, clients have mentioned that, oh, jewelry to be given between two daughters-in-law, but no two pieces of jewelry will have the same weight or the same value or the same constitution. How do you divide it? You can't break up, one necklace into two and say half and half. So we always tell them that, either you put it in two separate boxes or you put it in two separate lockers. Just make sure that there are no disputes later for, these aspects. So we'll move to the distribution now. Now, see, you can mention.
1 second, one question on that, since this was relevant in the previous section also, and Sejal has asked, because I saw that. She's saying this is all about asset. What about liability of a person?
Yeah,
then what is to be done? And I saw that there was a liability section there.
I'll just take you the liability section. So your home loan, personal loan, all those things can be mentioned here. See, it's always important to understand. Let's say if you're passing on a house to your child, if there's a home loan on that, you can't separate the liability from that. See, of course, if there's an insurance, it'll get paid off, etc. But the aspect is that those liabilities can also be passed on. So you can mention all those liabilities here too.
So my understanding here, Aditi, is that the liability does get passed on, which is why as advisors, wealth advisors, we always recommend having an insurance against any of the major loans.
Absolutely.
So, Sejal, I mean, the solution lies with the advisory piece, where most of a good advisor will always tell you that for all your home loan, personal loan, business loan, everything, when they're doing your insurance coverage calculation, they recommend, because the liability also passes on. So an insurance coverage helps there, right? Is that understanding correct?
Yes, there is. And to be very honest, always, even when we're looking at passing on assets, it'll always be first your debts have to be paid off.
Yes.
And then whatever assets
wo bachega, phir wo distribute hoga.
Yes, wo bachega, phir wo distribute hoga. So that is why it's a simple calculation, right? Just because a person is not there, the financial institution is not going to, just like chill and say, okay, the person is not there anymore. Somebody will have to pay for it. So it's either the insurance guy or obviously it gets paid off from your assets.
And here I'm going to do a quick plug, especially for life insurance. All the women here who are married, you must get a MWP addendum done. It's the Married Women's Property Act for your life insurance, which basically safeguards that any life insurance money will come to you and or your kids, and it will bypass any creditors. Even the law doesn't have kind of a right, the court doesn't have right on that money, and this is extremely highly recommended from our side. A lot of women don't know about this. So yeah, that's a parallel.
Absolutely. Yes, this is all a part of your financial hygiene to make sure that you're taken care of. This is the crux of this whole planning. Okay, coming to distribution. Now here you can distribute asset-wise. Let's say if you want an asset to go to a particular person, it goes accordingly. So let's say residential house, if I've mentioned here, it'll go to, so I'll just show you an example. Okay, so first is primary beneficiary. Let's say there's a house, there's this, who does it really go to? You mentioned your, you can either mention a percentage, let's say 50-50, or you can mention 100. Now there's very important clause called as a residuary clause. Now see what happens. Let's say today if I make a will, tomorrow, let's say I book a fixed deposit. Do I need to change my will tomorrow? The answer is no. This clause covers you. We've seen so many bad wills in our careers. Now, let's say this particular clause will say all those assets which either I get in the future, or let's say which I have missed out on mentioning. See, let's say you may even receive something as inheritance. All those assets are taken care of in the residuary assets clause. So this becomes very important. Now, I've mentioned here, let's say my spouse and my sister are 50%, they will get off this asset. Now, secondary beneficiary is who will get it next in line. See, this is a mock app, so you just excuse that I've written a spouse here, but essentially the important aspect is, if let's say my husband and sister are not there, who will get the asset? So then you need to mention your next in line regarding the secondary beneficiaries. So
like my friends be beneficiaries?
Absolutely, anybody can be a beneficiary. They don't have to be your relative. Okay. You can give, that's the beauty of a will. You can pass it on to, whoever you want. Okay, coming to a will executor. This is the
part. Stop smiling. I'm not sending you any of my assets.
So essentially, this is our executor. We also talk about a backup executor. So see over here, if you click, you'll come to know who an executor is and how do you select an executor. So there's enough literature that you'll have. Now, one important feature of the app is that you can even notify your executor. So your executor will know that, okay, they've been appointed as one. This is for guardians. So again, you appoint a guardian, backup guardian, and this is the witnesses section. You can either add your witnesses right now and then, generate the will, or otherwise you can add it later. Now see, when you generate the will, when you click on generate will, that is when all the legalese will be added. So I'll just take you through the preview now. This is how your will look like. So you'll have my last will and testament, and all the assets will get covered here. See, all the legalese we've done. I, so and so, this is the declaration, sound mind, all those things will be added. So this is how your final will document will look like. Now, after that, you have witnesses here. So you need to, so essentially what will happen with the app is when you generate a will, it will hit your inbox. And then you have to take a printout and, you need to sign it, and you have 2 more witnesses here. So this is exactly what your will look like after you've generated it from the app. So, there are more and more features added. Video recording is being added. I'll talk about the importance of video recording. All those, features to make sure that your will is a robust one. All those aspects are added here. I'll stop sharing my screen now.
This is fantastic, Aditi. Thank you for running us through this. I'm sure a lot of people will go and access the app or the page. And we'd love for you to, also share with us at the end, which I can circulate to everybody in the community, the links, etc., so that they can have a look.
Absolutely. So you can see a QR code on every slide. You can just, scan it and you'll be able to download the app as well. All right. So now we'll talk about what are the good to haves and must haves. So then that will make your will a very robust one. See, it's important to understand that anything, people also feel that anybody can challenge your will, See, but to be very honest, anywhere in the world, nobody can stop you from going to court. But the point is that, will the court really set aside your will or not? That is the important aspect to realize. See, even Bal Thackeray's will was challenged. He had a doctor and a lawyer as a witnesses, probably the best combination that you can have. But his will was challenged. The court said that no, you've not come to court with clean hands. This is a genuine will, and we are not going to set it aside. So then the will was held good. Now, all these things, if you just take care of, these tips that we're going to share, so your will can become a very solid one. So first, let's see what the law requires, or rather the must-haves. 18 years, sound mind. I think by now you're very comfortable with these 2 aspects. Now, always add very clear wishes. We always say that, see, honestly, it's important to note that just making a will is not good enough. You have to make a good will. We've seen enough bad wills which have, just created more trouble. I'll also share a case with you. This was at Yellow. We were helping a family. Father wrote a will. Basically, husband wrote a will. Wife did not write a will. This was again COVID. Passed away in quick succession. Children studying abroad had no idea about the assets that parents were having here. They had to reach out to neighbors, scurry around the house to see what they could. They took more than a couple of months to figure out what assets, was apparent, papers they found, etc. Now, in such a case, ideal thing would have been like you add, make both husband, wife, both should make separate wills. And who's the next in line? He just made the wife as a beneficiary and that's it. So they had to again go to court, get all the papers. It was a nightmare. So that is why we mentioned that make a good will so that your family is aware of what you have. So always add assets in your will. Honestly, you would have seen even in the app, we don't ask for values. My bank account having 5 lakh rupees. Honestly, the value is of no importance because values will keep changing. I may have a lakh tomorrow. I may have 10 lakhs tomorrow. It doesn't matter. But mention the bank name, branch, and the account number. Enough identifiers so that, even when you have to go and, access the asset, you should have details. For immovable property, write the flat number, building name, where is it, PIN code, all. If it's a land, then how do you identify the land? What are the survey numbers, khata numbers, whatever is applicable. You have to sign it and 2 more witnesses. And lastly, I've already covered about an executor. That's also important to add one. Now, what are the good to haves? Video record, the will. You can read out the will. We have a video on YouTube on how to do a video recording of a will, so you can check that out. So make sure, because that also creates a good solid evidence that you've created a will in your sound mind. Get a doctor's certificate which will say that you're physically and mentally of good health. Now, when it comes to registration, although I mentioned that registration is not compulsory, however, at the time of asset transfer, in many parts of India, we've seen that the local authorities, that either the municipal authorities or whatever, they tend to rely more on a registered copy of the will. Again, registration is not an expensive process. You have to go to the sub-registrar's office and get it done. It can cost anything between 5,000 rupees to 10,000 rupees. You can invest accordingly. See, registration becomes important, especially if you have land or any immovable asset. If you're only dealing with movable assets, it's okay. You can kind of, no need to register it. So we at Yellow also help with registration. So if you've got any specific part in India you're looking at, you can just reach out. We can give you a quote. And if you want to go ahead, you can take the services. Keep your ID proofs updated. This seems like such a simple advice here, but we've had clients which had 3-4 different variations of the name. Somewhere it was like, to give you an example, T Raman. Somewhere it was like Raman T. Somewhere it was like, whatever, whole name and then just an R. It was crazy. We are like, look, your family is going to curse you. Just make sure, just get everything in order and synchronize everything. So, because honestly, initially when Aadhaar was made, there were a lot of mistakes that we could see in documents, So just make sure that everything is in order. Do update your will from time to time. I've touched upon this. And lastly, very important again, inform your family members that you've made a will. We Indians think of a will as a very secretive document and we put it in the bank locker. But most people don't know that to access that bank locker, they will ask you for a copy of the will. So this is also becomes an issue. So please don't keep it in the bank locker. You keep it at home. You give it to your executor. At least make an additional copy. On the app, you can actually even upload the location of the will. So that can also become easy, for it to be identified. Okay, I think with this, this is the end of the presentation. I'll take probably just 2 more minutes to, just quickly take you through the services at Yellow. Essentially, this helps you to create a legally valid will. You've seen, it's easy to use. You add in the details. There are 2 more aspects here. One is we also have an in-house team of lawyers. Sometimes we do understand this is a legal related topic. You may have a legal question on any of your asset class. You can book a call with us and we can help you. And we also provide post-demise assistance. I'll just take you through that. This is the app part, where we have 256-bit AES encryption. So which means that this is highest, industry standards when it comes to security. So like any bank employs this, we also take care of your data as much. And Yellow can't review or read your will at all, because all this is masked, data is masked. This is all stored in a zero privacy vault. So we don't have access to your data. Now, there's also something called as Yellow Smart Services. Essentially, any asset which is there in India, we help you to, access. So either which is opening bank accounts, which is closure of bank accounts or pension accounts, land, any legal paperwork, all those things can be taken care of. See, we are also aware that many people may not have made a will. Even then, if you've lost a loved one and you want help to get any asset, we can help you with the paperwork. So at least we'll try and, ease whatever issues that you're facing. We'll give you the best possible solution. Now, these are plans, but do hang around, because we have a special code for our lovely ladies over here. So do hang out for like 2 more minutes with me. Okay, how can you use a yellow plan? When first part is, during lifetime that you're creating a will, there are 2 ways. One is you can directly, download the app. Exploring the app is free. You don't need to pay. Only when you generate a will, they'll ask you to pay. So you can feel free to download and explore. So when you download the will and you create your own will, it's for 899 rupees. We also have one more plan, because like I said, we do understand sometimes you need legal consultation, or sometimes you just want a lawyer to take a look at it for peace of mind. Ki chalo, I've made a good will. So for that, you pay 1,999 and you get 2 lawyer consultations free. The second method is that for asset transfer post demise. So again, there are 2 ways. One is that if you've lost a loved one, you reach out to us. So even if it's without a will, we'll help you with all the paperwork. And second is, this is something like an insurance. You pay a yearly amount. This depends on your age, but it starts with as less as like 1,500 rupees. If something were to happen to you in that year, Yellow takes care of the entire asset transfer services. So you don't need to pay for professional services. Only the statutory fees which are there, which is the government mandatory fees, those fees you need to pay, and rest everything we take care of. So you can probably, go to the app or website. We also have a website, web app. So you can explore over there and you can just see which plan is more suitable to you. These are all the companies we've worked with, but I wouldn't spend time over here. I think we'll focus on getting the replying to the questions and any other queries that you have. So we'll pick those up.
Girls, don't miss out. There is a special code, the Womoneysta 15 code, which is valid till 31st of October. And you can apply this and go via the Yellow app if you want to get started with your will creation. We'll share all this information with you on the community as well, so that you all can look at that. Just one last question, Aditi. Is there a way that anybody from the team, if they want to kind of from the community, from the team, want to reach out and have just questions? Like, is there a place where they can kind of book a one-on-one, which is
absolutely. Absolutely. So there are 2 ways. If you have any app related questions, let's say you're going through the will and you're stuck somewhere in the app. So you can, we've got app experts. You call, the phone number is here, or you WhatsApp us. And this is for free. You can call as many times if you have any app related queries. Also, if you want to book just a legal call, just to understand things. Even if you don't want to make a will with Yellow, you can reach out to us. We charge around 999 for a half an hour, 45 minutes call, and you can have your query sorted. So you reach out to us and we will make sure that, we guide you through the process and we'll take you through everything.
So even for that, are you going to help us with the code? So we will let them all know that.
Most definitely, yes. So do let us know that you're from Womoneysta. So that is important, and then we can do this.
Perfect. So we'll circulate both these things to the community as well. And we've already overshot your time, Aditi, by nice long
It's my pleasure. It's my
20
pleasure.
minutes. So I'm hoping, ladies, if you enjoyed this session, we will share a feedback request on the community. Please tell us, and we'd love to do more follow-up sessions with Yellow, because I don't think one session is enough. And that's at least my hope, but only if you all want it. We go back to them and we kind of help them, work with them to curate something which is relevant for all of us. Thank you, everyone. Thank you, Aditi, for making this so engaging. Such a wonderful session. So many things to think about today. This weekend is going to be lots of conversations with my mom, I know. So thank you so much for doing this for all of us.
Thank you so much, Neha. Thank you for giving me this opportunity to be here. And, in fact, Neha, the very first call that you had, I think you spoke to Nikhil, I think the very first.
Yes.
And we were so positive. We were like, yes, the vibes, we just vibed basically. But essentially, yes, this is, this is very important. And like I said, do think about this. Of course, you're free to use the Yellow app, but irrespective, just make a will. And that is what our aim is, so that you don't need to go through any hardship. With that, thank you so much for spending time on a Saturday afternoon. I know a hearty meal probably awaits you, but with that, thank you so much.
Thank you, everyone, all the ladies who've stayed back. And I hope this has also had added value and made you also go back and think about this. So my last cent, this is your money. You've got to take care of it. You're in charge, you're in control. And these are small and important conversations we'll keep having regularly. So keep encouraging us and we'll come back with something new every time. All right. Thank you. Bye, everybody. See you.
Bye.